This committee will come to order. Roll is open.
Mr. Chair, you have a quorum.
All right, we have a quorum. First order of business is we conducted before Skeleton Crew 2 final interviews for judicial positions. One was Chad Logan, who is a candidate for juvenile court in the 26th Judicial Circuit, and one is Judge Shannon Hoyle, who is a Hanover County juvenile court judge who is up for Judicial Inquiry and Review Commission. Is there a motion to certify those two as eligible for election? All right, it's been moved and seconded. The roll is open. All right.
Ayes 14, no zero.
All right, both of those candidates are now duly certified. All right, we're going to try and roll as expeditiously through this calendar as we possibly can. We have signed up first Delegate Van Valkenburg. Delegate, what bill do you have?
Thank you, Mr. Chairman. Members of the committee, House Bill 2320. This is a bill.
Hang on 1 second.
Oh, okay.
All right, go ahead.
Okay, thank you, Mr. Chairman. House Bill 2320 is a bill that clarifies who's responsible for bail, what court is responsible for bail modification. It comes at the request of the VCJC over confusion between localities. And
Shannon, any objection by the Commonwealth's attorneys to this?
No, sir.
You aware of any concerns about this bill? Anybody in the audience here speak in opposition to this VCJC bill? Anybody on the committee have any questions? Well, I hope you've read it.
Well, I want somebody to explain it very quickly.
Gives clarification as to when the appeal can be done from general district court to circuit court. For those who practice, there was some confusion as to should it be after preliminary hearing or wait for the certification of the bill of indictment. This clarifies it is at the time of preliminary hearing.
Isn't it, you can
Senator
always.
Edwards.
Can't you always go from the general district court to the circuit court on a bail issue?
Correct, but the idea was when was the jurisdiction going to be, so after preliminary hearing. So as you know, Senator Edwards, and sorry, Mr. Chairman,
Yeah, right.
Mr. Chairman, members of the subcommittee.
Okay.
Well,
Yes.
I got you.
those are
Okay.
kind of alternative, Olivia's, or can they go together? I'm sorry. Any other questions? All right, the bill is before us. Roll is open. I'm sorry, hang on, strike the roll. Is there a motion to report the bill? All right. It's been moved and seconded. Roll is open. Congratulations, Delegate.
thank you, Mr. Chairman.
All right, second we've got
Ayes 14,
Delegate
no
Bourne.
zero.
Thank you, Mr. Chairman. Mr. Chairman, ladies and gentlemen of the committee, House Bill 1924 is a recommendation from the Boyd Graves Commission. In 2007, Virginia adopted the Uniform Interstate Depositions and Discovery Act. In reviewing a number of issues related to that, the Boyd Graves Conference found that a statute that is predecessor of the UIDDA is no longer needed in light of the UIDDA's adoption. In fact, the code section that we're going to strike dates back to 1825 and, to my knowledge, hasn't been used.
And Delegate, I guess the only question that came up was whether this is going to have any impact on states that haven't adopted the act.
I have not heard that would be a concern or a challenge to the bill. The representative from the VBA and Boyd Graves doesn't seem to be here, or I could ask him.
Kristen, have you done any deep thinking about that?
I think it should be okay, Mr. Chairman.
All right. Anybody aware of any opposition to this?
Yeah, I did not have any opposition on the other side of the.
All right. Anybody in the audience wish to speak in opposition to this bill? All right. The bill is. Anybody on the committee have any questions? Senator Edwards?
No. Move
Bill is
report.
before us.
Move report.
All right. It's been moved and seconded. The bill be reported.
Mr. Chairman, I thank you for you and the committee's time.
You bet.
Ayes
Thank
14,
you.
no zero.
Delegate Simon.
Thank you, Mr. Chairman, members of the committee. House Bill 2679, I think, does.
This is identical, well, it tries to do the same thing as Senator Ebbins' bill. My suggestion is that we conform your bill to Senator Ebbins' bill, Servel's bill, thank you, and that we continue the dialogue and see which approach we like better in that process. Do you have any objection to that?
Absolutely none, Mr. Chair. I think that's the right way to go
All
about
right.
it.
It's, I'm sorry, somebody have a question?
1758.
Okay. All right, it's been moved and seconded to conform and report. Anybody in the audience opposed to that? All right, roll is open. All right, thank you, Delegate Simon.
Thank you, Mr.
13 is
Chairman.
one. Hang on 1 second. I'm sorry, you have more?
Nope.
Next, we've got Delegate Knight. Not here. What bill is Delegate Knight's? 1636. I think we can probably do this without Delegate Knight. Maybe. This, Kristen, is this yours? Charles? Can you tell us briefly what this does, Charles?
Mr.
I'm
Chairman,
not aware of any opposition to it.
House Bill 1636 basically makes it a Class 1 misdemeanor for a unmanned aircraft system, basically a drone, to take off or land in violation of current FAA special security instructions or UAS security-sensitive airspace restrictions.
Yeah, that's a good question. Senator McDougal. Just in time. Step up, Delegate.
what is
We're about to
UAS?
dispose of your bill.
I have House Bill 1636, and this bill,
We're going to jump right in and tell us what UAS means.
is a drone.
UAS,
Yes, sir.
security sensitive, UAS, unmanned aircraft system.
Yes, sir.
Okay, got it.
What it is Oceana, Master Jet Base, asked Virginia Beach to ask me that they've got certain areas around where they don't want these unmanned aircraft because they don't want a fighter jet coming in and a drone taking them out. So there's already federal law there. We would just like to have state law, so now that the local and the state authorities can help enforce this law to kind of keep Oceana there so we don't have a BRAC situation.
But one question that we had was, this says can't take off or land, but how about fly?
Well, the problem is FAA, you know, the Federal Aviation Administration controls that. We don't control that. So what we're trying to do is the only jurisdiction we have is on the land around it. So we're going to conform it to the federal statute, which is the land, but we don't have jurisdiction of the FAA of the airspace.
Fascinating. Does that make sense to you, Charles?
It does, Mr. Chairman.
All right. Anybody have any questions of the delegate? My understanding is that the unmanned aircraft systems industry is good with this?
Yes, sir, I think so.
All right. Anybody here in the audience who wishes to speak in opposition to this bill? All right. Anybody have any questions? Bill's before us.
Move report.
All right. It's been moved and seconded. The bill be reported. Roll is open. Your bill reports.
That's
Delegate
14-0.
Head.
Thank you,
You have
Mr.
another?
Chairman. No, sir, thank you.
Okay. Thank you. Delegate Head.
Thank you, Mr. Chairman. We have House Bill 2746. All this
bill does, currently you have a number of organizations that are required to run criminal background checks, and they are allowed to run both either the electronic background check through the Virginia State Police, or they can also submit to the state police to do a fingerprint scan. What 2746 does is just allows them to tie into the live scan devices that are available already for those that are in the child care industry. This just doesn't mandate it. It just says that if they wish to use that to expedite the process, that they are allowed to use those. They are readily available in a variety of locations around the state. They still have to meet the same qualifications. It doesn't give them any information that they are not already used to or not already it's not already available to them. They are still have the same restrictions that they would normally have. It just simply gives them the access to this device, which really facilitates doing a nationwide check rather than just the in-state only check. Currently, for them to do that, they have to have an employee go down and have the fingerprints actually physically taken, and then it takes 6 to 8 weeks. This just takes it from a 6 to 8 week turnaround time to many times 48-hour turnaround time.
Awesome.
So,
All right, anybody have any questions of the patron?
Move report.
Well, hang on one second. Are you aware of any opposition to the bill?
none at all. As a matter of fact, the Virginia State Police, so they don't have any position or have not stated a position on this. They have been very helpful in us getting the verbiage just right on this. And
State
they
Police,
want
I
to
see
weigh in
back
on
in the
that.
back of the room somewhere. You okay with this? Yes. All right. All right.
Move report.
Second. All right, it's been moved and seconded. The bill be reported. Ayes 14-0. Delegate Head, is that all you've got?
That's all we have. Thank you, Mr.
All
Chairman.
right, Delegate Poindexter, not here. What is his bill? We'll come back to that. Delegate Orrock,
Good afternoon, Mr. Chairman, members of the committee. May we take up House Bill 1624 first, please?
good lawyer bill.
Mr. Chairman, members of the committee, I've been made aware of a circumstance whereby certain individuals kind of go around, file various civil suits, and it's basically just trying to get a settlement without going to court. Under current law, if it appears before the same judge, that judge, given this pattern of that behavior, can award attorney's fees to the plaintiffs. What I'm trying to attempt in this measure is, after the judge has rendered the decision, the defendant who has prevailed could give to the judge evidence of similar types of frivolous filings in other jurisdictions and be totally discretionary on the judge as to whether they wish to honor that or not. I'm aware of one particular case where 3 or 4 jurisdictions in the general area getting different substitute judges, one individual. This had pretty much become his vocation.
Now, and I mean, well, I may mean a little harm to your bill, but I mean no offense.
Right.
You know, I don't understand why a judge can't do that anyway. And as a matter of fact, judges take evidence frequently about the nature and I guess how bad the bad conduct is. And, you know, every once in a while, a judge will say, that's another case, I can't take it into consideration. But what that judge might really mean is, yeah, I'm not going to sanction the guy, and I'm not telling you why. I'm just not going to do it, and I'm not going to deal with it any further. So, you know, the question arose in discussing the bill whether the judge had this inherent power anyway.
Mr. Chair,
Senator Peterson.
let me, and for those of us that do this for a living, let me sort of say what, the statute's 8.01-271.1, which says, before you file a pleading, before you actually sign it and file it, you will verify that it has a legal or factual foundation to it. And if it doesn't, you may have done nothing wrong in your career. You can be liable for anything you file that lacks a legal or factual foundation. So I feel like in some ways it kind of gets it off kilter. It's almost like, well, you know, if you had a prior criminal offense, should it be evidence of whether or not you committed a criminal offense? You know, I guess I'm a little bit kind of surprised that a non-attorney would bring this in, because this is a statute that really only applies to lawyers.
And it may have not been put in the most artful place, because, Mr. Chairman, what I'm trying to get to is a circumstance where the plaintiff is filing charges against individuals. They know they're going to have to take a day off from their job. They may have to get a lawyer, and so they're going to settlement. And all he's had to do is pay a $35 filing fee for a civil action. If it goes to court, he doesn't have a lawyer.
Right.
And if, since he doesn't have a job, it's okay.
Well, I think the $35 filing fee went away in like the 1970s.
Okay. See, it shows how much I know about the law,
Yeah.
but anyway.
80s, 90s.
I'm just trying to create a circle, because as was explained to me, right now, the judge, unless it was in his purview of knowledge that there had been a pattern of this individual filing these types of suits, then he can't consider that if the prevailing defendant felt they were entitled to attorney's fees because they came in. That's all I'm trying to get to, and this may not be the most artful way to do it.
Senator Stewart.
Mr. Chairman, I understand what Delegate Orrick's trying to get to. It's really frustrating because you do get these attorneys who are not playing by the rules all the time.
And these aren't attorneys who are doing it, so maybe that's the challenge. This is just a private citizen filing a civil action.
And, well, you get that too. And judges do not like to order sanctions, has been my experience for conduct. But I believe, and I want Steve Benjamin to correct me, I believe that they can already do this, and they could take evidence after the fact of other frivolous filings. And what concerns me is when you state the obvious in a statute, if you don't state all of the other obvious things, then sometimes those things get excluded. So that concerns me a little bit. I'd like for Steve to help educate me, if you will.
Mr. Benjamin.
Mr. Chairman, Senator Stewart, I think you're right. I think you're right. I think the court could consider a pattern if there were any question about it.
Okay. Well, I live to the deference of the committee. I'll understand my
Now,
objection.
I understand, and I think you have kindred spirits up here who do not want to sanction, meaning approve, that behavior, would like to see a more aggressive approach, but I'm not sure that this is necessarily going to achieve that.
And with all due respect to the patron, who's one of my favorite delegates, Mr. Chairman, I'd have to move we pass this by indefinitely, just because we have a long docket.
Sure.
All right, the motion is to pass bill by indefinitely. Is there a second?
Second.
All right, it's been moved and seconded. The roll is open. All right, Delegate.
Thank you, Mr. Chairman. And I also have House Bill 1626.
Another one.
And on the previous matter, if I'm back, I may be back with a different version of this when they're all just killed. But anyway, Mr. Chairman, 1626 was brought to me by individuals who are part of the cockfighting task force. And they have shared that they seem very, they're very frustrated when that they may, as a matter of practice of normal being out there animal control, they pull up on a farm, they see roosters that are tethered, but they can't do anything about it. That in and of itself does not give them grounds to be able to look for any cockfighting paraphernalia, things of that nature. And so the attempt here is that if they see cocks that are being tethered outside, that may be probable cause for them to do further investigation. Doesn't mean they have to. The parallel, as was explained to me, would be like in a traffic stop, if they smell marijuana, that's probable cause to do more, but absent that, they can't do any more. And that's all I'm trying to achieve, Mr. Chairman.
Senator Stewart.
Mr. Chairman, I need help with this because what I understand probable cause to be is the articulable suspicion that criminal activity is afoot, and that has been set by the court. Correct, Steve? And do we set in statutes what probable cause is?
Mr. Chairman, Senator Stewart, your definition of probable cause is correct, and no, we don't, in any other place in the code, provide for what constitutes probable cause. My additional observation is that if an officer saw something, any condition, including a tethered cock, that gave him reason to believe that there may be criminal activity going on, they would already have the authority to investigate further.
And apparently there have been some Commonwealth attorneys in some of these regions who didn't feel that same way, apparently, so they shared with me.
Okay. I see that you have a couple of witnesses behind you who I assume want to speak in favor of your bill, and we'd be happy to hear from them. And It's not a signal of disrespect that we're going to apply a timer. It's just some of the time constraints, but we'd be happy to hear from you.
I'm Michelle Welch. I'm the Director of the
And
Animal Law.
that's a timer for everybody.
Okay, Director of the Animal Law Unit from the Virginia Attorney General's Office. I am a member of the Virginia Animal Fighting Task Force. I think the nexus and the reason they asked Delegate Orrock to do this is that sometimes magistrates believe just a tethering of a rooster is not enough for probable cause. And so that is the reason why they wanted to insert the probable cause standard for this particular statute. I will say animal fighting is unique because not a lot of magistrates and not a lot of judges and not even a lot of Commonwealth attorneys have done those. We have reached out and actually helped. We have 6 animal fighting cases right now that we're helping Commonwealth attorneys on. So this is why there's a need, and we'd ask you to support it. Thank you.
Mr. Chairman, Matt Gray with the Humane Society, also speaking on behalf of the Virginia Animal Control Association, voicing our support for this bill.
Thank you, Matt.
Mr. Chairman,
Hang on 1 second.
it was actually over here.
All right. Mr. Benjamin, you have some thoughts or observations or questions about
Yes,
this?
Mr. Chairman, the question for whomever can answer this is, are these birds ever tethered for any lawful reason?
And that,
These are they're tethering roosters, and no legitimate farmer would tether their roosters. That's not normal. And the other thing I will tell you is that they have a disproportionate number of roosters to hen, almost like 65%, 75% roosters, and they're all tethered out because they've trained them to fight, and they will fight each other if they don't
Okay,
have them
I just
tethered
wanted
out.
to determine whether there was some legitimate reason. Another question, Mr. Chairman.
Mr. Benjamin.
I see that the bill modifies subsection C. Subsection C deals with confiscating animals that are used in fighting. Was it the patron's intent, Mr. Chairman, that that the probable cause provision permit the confiscation of the animal?
Well, I'll tell you that right now, the way their law is, I only have to prove probable cause to seize any
Let me ask my
animal
question a
fighting
different way.
animal.
Is that your intent, that you make it easier to confiscate a tethered bird?
Or to
No,
prosecute.
it's more about getting that search warrant.
Okay.
So maybe it should be in a different spot.
That's
but-
my concern, Mr. Chairman, is that where it has been placed in subsection C, it sounds like it applies to the ability of the officer to confiscate the bird.
The standard right now, I'm sorry, the standard right now is probable cause to forfeit any animal fighting animal.
Steve, do you have a suggestion to help?
I could help it, I could help if we were dealing with just confiscating the animal. If we can pass it by, I think actually Charles had an idea. If we can pass
Senator
it by,
Stewart?
we'll come up with some alternative language.
Mr. Chairman?
Well, I
Hang on
mean,
1 second.
we had a thought about the confiscation part of just saying on line 33, confiscate any tethered rooster, cock, whatever.
That was my
But it-
suggestion.
It doesn't get to the prosecution part.
If you look on line 33, after the word confiscate, you would insert any tethered cock, comma, or,
other animal.
yeah,
Or
and
other
then, so
animal.
if an
Yes.
officer sees a tethered cock, they can confiscate the tethered cock. And then it is eventually up to the judge as to whether there's probable cause, but that's current law.
I think that
Would
works.
that satisfy?
I believe that would satisfy the intent of the
I'm
individuals.
about to
I was gonna
re-refer this to Ag.
Again.
This is why we sent it here, because we needed
All
smart
right.
people to
You
look
want
at
to
this.
make that motion?
I move that amendment.
All right, is there a second? All right, that amendment has been moved and seconded. You okay with that?
Quite.
All right. All in favor of that amendment signify by saying aye. Aye. All opposed? That amendment is adopted. Anybody here in opposition to this bill? Bill is before us as amended.
The report.
As amended. All right. All right, that bill passes. Do you have
Thank you, Mr.
another, or is that
Chairman.
it?
That's it. Thank you, Mr. Chairman, members of the committee.
All right, thank you. All right, Delegate Mullins, step right up.
Mr. Chair, it's good to see you again.
Good to see you.
I have HB 2118.
Sorry, 2118.
Yes, sir.
Huh? This one looks easy. Anybody have any questions about this lab certification bill? You aware of any opposition to this bill? I take it that the administration's good with this bill?
They are.
All right. All right, is there a motion on this? It's been moved and seconded the bill be reported. All right, the bill reports. Now go make a quorum in
14-0. Thank you, Mr. Chair.
House courts. All right, we're going to take up next Delegate Sullivan.
Good afternoon, Mr. Chairman, members of the committee.
Delegate Sullivan, good to see you.
I can feel the momentum in the room.
You definitely haven't been in appropriations across the hallway.
I'll try to make my remarks briefer than they were going to be. I know it's getting late. Members of the committee, Mr. Chairman, you know, there are a lot of Virginians from all walks of life and from all around the Commonwealth who are eager to start or expand their families. But they're unable to do so for a variety of reasons, in the same way that most of us here did. And a lot of those reasons are medical reasons, but others as well. And they have turned to what's called assisted reproductive technology. ART is the term of ART. The Virginia Code has recognized ART for 25 years, first passed the statute in 1994. And what HB 1979 does is updates Virginia's surrogacy law statute. I should stop probably at this point and say there is a substitute, which I think has been, and I'm happy to.
Senator Stewart moves, Senator Howe seconds the adoption of substitute. All in favor of adopting a substitute signify by saying aye. Aye. All opposed, substitute is before us.
Thank you, Mr. Chairman.
Now, and Delegate Sullivan, just so we can kind of get to the nub on, and I don't want to interrupt you, and you can go back to your presentation, but the substitute largely addresses some of the concerns about the commoditization of embryos.
I'm not sure it's the commoditization. What happened over in the other body is there, in the original version of the bill, the word owned was used in several places, or ownership was used in several places.
Treats them more
with respect to the embryo.
Right.
And what I can
an
do
embryo is more as a human being than as personal property.
Sure. Well, what I explained to my colleagues, both in committee and on the floor, is that, again, in this area of practice, that is, while it's a phrase that kind of hurts your ears and hurts your eyes, it is the way these things are dealt with. I can tell you, for instance.
But are we treating the embryo as a human being or as property?
We are treating the an embryo as something that someone or a couple has control over the use of.
Well, it's either a human being or property.
Well, I'm not sure I agree with that, Mr. Chairman, with all due respect. But for instance, let me tell you, I'm looking at sort of Virginia's most groundbreaking case was decided just a year or so ago by Judge White in Mecklenburg County Circuit Court. This is a case, this is happening with greater frequency around the country, of a couple that had frozen an embryo because what happened was they had a child, and the wife got sick with cancer and was about to undergo a course of chemotherapy and some surgery, and they wanted to have another baby, so they created an embryo, and that embryo was cryogenically frozen. Then, of course, you know where I'm going, they got divorced. And as a part of that divorce, the question became what to do with this embryo. The husband wanted to destroy the embryo. The wife wanted to have another child so that their existing child could have a biological sibling. The court, and this is, again, as I said, it sort of hurts the eyes and ears, the court dealt with this under the equitable distribution portions of the code, awarded the embryo.
And I think that's what some members had some difficulty with.
Correct.
And that's frankly why we come to the legislature sometimes, is because we think that the definition that's been adopted, may need to be changed.
So
That the courts, are operating without the guidance that the General Assembly is supposed to give.
So returning to your original question, Mr. Chairman, in every case, and there were 8 places in the bill, where some form of the word owned, past tense own, or ownership, wherever that appeared, the substitute before you replaces it with 10 words instead of 1. And those words, I'm looking, for instance, at page 106, line 107. Instead of saying the embryo was owned, what it says is the embryo that was used is subject to the legal or contractual authority over the use of the embryo by an intended parent, either because of a court order or a contract of some sort. And in every place that own or owned or ownership appeared, the substitute describes it in that way rather than using words like ownership. The 13th Amendment took care of ownership of human beings a long, long time ago.
Mr. Chairman. Delegate Sullivan.
Yes, sir.
This whole issue of ownership's given me a great deal of uncomfort. And so I've looked at this definition and I have a question. Could we use the word custody instead of authority?
Subject to the legal or contractual custody?
Custody rather than authority?
Mr. Chairman, Senator, I appreciate the effort, and I actually thought of that word, but again, this is all high tech, and so it's sort of hard to describe. In most cases, in fact, indeed, in every case, the actual custody of the embryo is at a cryogenic facility.
Wow.
The people who created the embryo don't have custody of it. Literal custody is at a facility, an IVF clinic or a cryogenic facility.
Well,
So they have, that's why I chose the words
But it says-
authority over the use of it, because
Mr. Chairman.
But it says, subject to the legal or contractual authority over the use of the embryo by an intended parent.
correct.
Why can't you substitute custody for authority? Because it still goes to the same thing, but it is a legal term of art that we use already with children versus authority.
I'm worried about the literalness of the word, Senator. Someone else has custody of it.
Well, how about
It
this,
is, it's in another place.
Mr. Chairman?
Senator Edwards.
How about, say, subject to, what line is it on again?
As an
1A.
example, line 107.
Okay. Subject to the, let's see, but the embryo used is subject to the legal or parental custody over the use of the embryo. Because parental custody is a pretty well-defined term.
Mr. Chairman and Senator Edwards, again, when you start to, in this area of the law, when you start to wade into using words like parent, that's sort of what this bill is all about, is describing who the intended parents are. And in some cases, the intended parents aren't the biological parents of the embryo.
Well, I know that, but.
Yeah.
Okay.
Right. Go ahead.
Thank you, Mr. Chairman.
It's just like court. We want to get to
Exactly,
the
you
things
got to
that,
take the questions as they come.
I always want a judge to tell me what concerns him.
There's not a big secret that it's 1979 has become a bit of a flashpoint, Mr. Chairman. It has a few detractors out there. Frankly, I guess naively thought that I might have the support of the Family Foundation on this, because this bill is really about promoting life and about promoting family. But that didn't happen. So let me just tell you a little bit about what the bill doesn't do before I focus, of course, more clearly on what it does do. We've talked about the ownership issue. It also does not promote commodification of human beings or the sale of babies and embryos. It's already illegal in Virginia to do that. The next section in the code, I think it's actually a part of the bill, talks about you can't broker embryos. So this is not what this bill is about. Neither does it, the words have been used in opposition to this bill, encourage the creation of babies without parents. Frankly, it's quite the opposite. These people who want to use these embryos are desperate to become parents. and to become the parents of the child that this embryo could become. It's not like Senator Serval's bill earlier, where we got wrapped around the axle on the presumption language. Frankly, with all due respect to, I guess, some of the people you're going to hear from today, the bill has been terribly, in my view, mischaracterized as to what it's intended to do. As I think most of the members of the committee know, the bill is inspired by my constituents, Jay Timmons and Rick Olson, who are here, along with their children, CJ, Ellie, and Jacob. That's Jacob in Jay's arms. The bill has come to be known as Jacob's bill. So I offer them as my exhibits A, B, and C, CJ, Ellie, and Jacob. They're all here today as a result of this art technology. Jay and Rick had all of those children using this technology. As Jay is going to tell you, the two girls are biologically related to one of them, but Jacob was not. He was the product of a donor embryo. And Jay and Rick faced huge legal hurdles to start and then to expand this family, requiring them to leave the state in order to accomplish it. So Jacob's Law is meant to ease this process and simply make it easier for Virginians to create families like Jay and Rick's family. Let me tell you what the bill does do, Mr. Chairman and members of the committee. It gender neutralizes the statute, which is something the Code Commission has been talking about for a long time. It applies to a single adult, just as adoption has. Now, one thing I would say is, we have gender neutralized and updated our adoption statutes to deal with a single parent. The General Assembly's already looked at that over the last 25 years, but the art statute's been sort of left behind. And think about, there's been some concern about the single parent. Think about Mrs. Patel in the case I told you about, right? She was about to be divorced. She was about to become a single parent, yet she wanted to have, through this art technology, she wanted to have a biological child so that her first child could have a sibling. So this would allow Mrs. Patel, in the case I told you about, to use these statutes. The other things the bill does is, under this language, you would no longer need to adopt after this process when a donor embryo is used, which is an incredibly time-consuming and not to mention expensive process. And it clarifies that only a traditional, that is a biological surrogate, can void the contract and actually keep the child at the end of the process. So those very specific things are what it does. It does not inject any new technology into Virginia's statute. It does not create a new way to have children other than what is already allowed in Virginia. But what it does do is allow more Virginia people, citizens, to have the kind of families that Rick and Jay have. Rick and Jay's family is a miracle of modern technology. And it's a miracle of the power of love. Now, these are children, the products of surrogacy contracts are children that will never have to worry that they weren't really wanted, right? Or that have to ask their parents, gee, was I an accident? These families and the parents of in these families go through incredible expense and incredible feats of love to do this. So this, one of the accusations about this bill, Mr. Chairman, is that this is a public policy that creates a devastating public policy. Those are the words that are used, a devastating public policy. It seems to me that it's quite the contrary, that what this does is create a public policy of which we can all be very proud.
And I haven't heard that, and maybe it's in some written materials.
It is,
and I don't
yes,
think
sir.
that you will find people on this committee who feel that. I think that a lot of us share some of your goals, would like to do something, that unfortunately we don't have a Senate companion. So this is something that came to us really late in the process, and we haven't had as much time to cogitate, review, and work over this bill as some others. What I would like to do is, first of all, I don't know whether any member has any questions of the patron, but I know that there are people here who came who
have
would
some
like to
witnesses.
speak in favor of the bill, and some who would like to speak in opposition of the bill. And you
Mr.
point
Chair.
out that it is a bill that has generated very strong emotional feelings on both sides. And I want to say that We are going to apply a time clock because we don't have much time.
I understand.
And it's not out of any lack of respect to the people who are impacted by this bill. And we'd love to hear from people who support the bill first.
Mr. Chair,
Senator Peterson.
before we get to the witnesses, I just want to be 100% clear, and I think you're saying that the couples, it would be a married couple or an unmarried individual.
Well, what I was suggesting, Senator Peterson, I use the example of the unmarried, the divorced mother in the Patel v. Patel case.
Right.
She was about to become a single mother. She won that case. The judge awarded, it was Judge White, awarded the embryo to Ms. Patel.
Right.
Because she wanted to have the child. And assuming she didn't quickly remarry, she would be a single parent, and she would be able to use this statute. And the statute does.
But it doesn't change the presumption of the married couple.
It does not.
That's
not.
all I had. Okay.
All right. Let's hear from those who would like to speak in favor of the bill. And we're going to put a 5-minute time clock on supporters and in opposition. But before I start the clock, I'd just say your first witness is a good friend to many of us up here. Jay, it's good to see you.
Thank you, Mr. Chairman, and good afternoon to members of the committee. I am Jay Timmons, and I'm the President and CEO of the National Association of Manufacturers. But I'm not here in that capacity. Instead, I'm here as a father in support of Jacob's Law, HB 1979. My husband, Rick Olson, is here. Our children, who you've already heard about, Catherine, Elizabeth, Jacob, we call them CJ, Ellie, and Jacob. All three of those children were born from surrogacy. Some of you know, and the chairman indicated that we know each other. Some of you know me from my days as Chief of Staff for Governor George Allen when we worked together. Former Delegate Clement and I were just reminiscing about my hearings back then. They were hopefully a little bit more pleasant than today. But Governor Allen, by the way, did ask me to relate to you that he supports this bill as well.
I think most of us have gotten phone calls from him.
I know. So our two daughters are biologically related to one of us. We were granted our parental rights through a pre-birth order in California. We believed our family was complete, but quite frankly, God had other plans for us. In 2013, a husband and wife couple with 4 children of their own approached us about expanding our family because they had decided their family was complete and all of their children were produced through ART as well because she was unable to conceive. Because we shared similar views on when life begins, they asked us to accept 2 embryos that had been frozen for over 13 years. They didn't want to risk that their embryos might eventually be destroyed. Our transfer to our gestational surrogate in Wisconsin resulted in a singleton, Jacob, who was due in mid-August of 2015. And as we did in California, we petitioned the circuit court for our parental rights, and we were assigned a hearing in late June. We appeared in person. Judge Sarah O'Brien conducted an evidentiary hearing, awarded us interim parental rights. And we simply needed to inform the court when the child was born. She was a reserve judge. A permanent judge was appointed, and in a nutshell, that judge, Judge Trupus, immediately moved to invalidate the O'Brien ruling, imposed a guardian ad litem on us, and questioned the validity of the state Supreme Court decision that validated the parental rights transfer and challenged whether there was a legal pathway for us to be Jacob's parents in an uncontested parental rights petition. So instead of a 24-hour ministerial action by the court to obtain parental rights that we were already granted by another judge, we endured over a year of legal chaos, fighting with a judge and a guardian who were clearly trying to score political and policy points instead of applying the law and adhering to a well-established judicial precedent. There were objections and motions, deadlines and delays, a stream of lawyers, unnerving, endless, sleepless nights, continual nausea so acute that we could barely eat just to manage all of the legal issues. Rick had to leave his job of 16 years at Capital One while I tried to focus on doing mine. Weeks of gut-wrenching agony turned into months until Judge Trupus finally issued his decree. He declared, after Judge O'Brien had declared us to be Jacob's rightful parents, Judge Trupus officially took those rights away. He also illegally terminated the surrogate's parental rights. He left Jacob deliberately an orphan and a ward of the state. And then he branded us human traffickers, Mr. Chairman. A third judge finally vacated Trupus's vile ruling and restored the original O'Brien order. after Troopus resigned in disgrace. But it was a year of emotional abuse, and it had taken a toll. Declining health from never-ending stress, second and third mortgages to pay the legal bills of 13 lawyers, 2 of which the judge ordered us to pay even though he was trying to take away our child. The constant fear of losing Jacob and having to somehow tell his big sisters. This bill doesn't solve every issue, to be sure, but it's a simple update of a statute that really should not be that contentious or controversial, and it frankly doesn't need to be amended to make it something that it's not. Let me quickly address a couple of the points that have been raised. The bill creates a presumption for parenthood not tied to biology. Well, that's exactly what traditional adoption is. And to those opponents who have made it crystal clear that voting against this bill, they're also saying that adoption isn't appropriate either, when they apparently believe 5,000 kids in Virginia's foster system aren't worthy of a loving forever home. Opponents complain that single parents would be recognized, and that's true. There's nearly 500,000 children in Virginia being raised by single parents today. You've likely seen some other insulting rhetoric going around, but here's the bottom line. We are a real family. This happened to us. The embryo that was Jacob would not have been rescued by us and would have been destroyed or used as scientific research if the opponents had their way. We're very passionate about this because it happened to our family.
Thank you, Jay. We'll register your support, too. Step right up.
Good afternoon.
And I'm sorry, but if you want to identify yourself and register your support or opposition, we'd be happy to hear that.
I'm Julie Sillo. I'm here on behalf of the Virginia Family Law Coalition. We are in support of this bill. Most of you, I think, have spoken with Colleen Quinn, who is a highly regarded ART attorney here in the Richmond area. She apologizes for not being here, and so I have come in her place.
Right.
For the reasons that Delegate Sullivan has expressed and that Jay has expressed, we support the bill. In addition, Colleen would have expressed her concerns about leaving our statute the way it is, having unconstitutionality issues under recent U.S. Supreme Court decisions of Obergefell and Pavon versus Smith. So we support the bill.
Thank you.
Thank you, Mr. Chairman. Briefly, Sam Towle, Deputy Attorney General for Civil Litigation. Just wanted to inform the panel that this will solve the nonconformity issue and the potential liability in 20-158 that we discussed with a previous Senate bill. Thank you very much for your time.
You all support it?
Yes, sir.
All right, thank you. Those who'd like to speak in opposition to the bill.
Mr. Chairman, Senators, I am Olivia Gans Turner, President of the Virginia Society of Human Life. This amendment has many, many, many problems and obviously has caused a great deal of confusion and consternation among many of us for a lot of good reasons. Virginia Society of Human Life is concerned about going forward with this amendment, but we are mostly concerned with the reality that the existing law already creates within it a very dangerous scenario where contracts are being formed with couples creating these embryonic children, and those children under those contracts very often could be killed or destroyed either during the embryonic stage or later in pregnancy through pregnancy reduction. We have proffered to you all an amendment that might be possible as not just a remedy to this amendment, which has many, many flaws and is disturbing, but to the law itself in Virginia, and it's long past due. It's something that perhaps is a first step in the right direction, but overall we are displeased with the amendment because it doesn't address any of those concerns and raises many, many others. Thank you so much for your attention.
Thank you very much. Yes, sir.
Mr. Chairman, committee members, my name is Josh Hetzer with the Family Foundation. This says there's come to be a lot of attention on this bill, and for good reasons. It represents nothing short of a seismic
Josh,
shift.
first of all, the substitute that was introduced, I mean, that addresses your personal property issue, doesn't it?
I believe it does.
Okay, so it's better than it was when it came over here, in your view.
Yes, we believe that portion is better than it was.
Okay, so can you tell us, hone in on what your specific objections are, if you would?
Sure, there's a couple of things that this bill does. The bill would sever the biological connection between the child and his or her parents for the first time ever. We believe this is very significant because it would replace the legal basis for parenthood to be a mere contract between willing adults. And we believe that ultimately could undermine all parental rights. For the first time, this bill, a child could be intentionally and permanently deprived of either a mother or a father. We think that's very significant. And we all know how important a mother and a father is in an individual's life. We have concerns about single.
Well, and you and I talked about this, but, you know, aren't we weighing protection of life against your concern about the significance of a mother and father?
I think, well.
I mean, isn't that what you're asking us to do is?
No, Senator. I think we all agree that life, all life matters and should have the opportunity to develop. We disagree that this is the way to do it, because what we think this will do, and what we feel certain this will do, is only incentivize people to go and create more and more and more lab-created human beings. There's a reason why we have between 600,000 and 1.2 million of these snowflake babies, so-called. And it's because incentives have been created through public policy to do so. And we believe that this would open up a number of new bases to make more and more and more of those.
Senator Stewart.
Josh, one of the first things you said kind of struck me and helped me with this. You said that for the first time we would cut that bond between biological parents. Haven't we already done that with adopted children? And don't we try to find homes for children that need to be adopted?
Mr. Chairman, Senator Stewart, I think it's a good question. And I would say there's a big difference between what we're doing with adoption and what we're doing here. And the difference is, the situation with adoption, you're dealing with a broken situation. And we're using the best tools that we have to try to address that. But here, we're dealing with someone who hasn't even been conceived yet, or now is conceived but hasn't been born. And we're talking about allowing people to create human beings in a lab such that we would intentionally deprive them from the very beginning of those parents. But that isn't the way it happens with
Aren't we also talking about children who've already been created and finding homes for them?
Yes, Mr. Chairman, and there are ways under our current law, though it is imperfect, and perhaps we can make it easier. This bill goes pretty far, but those have to be dealt with. But we're very concerned that this will not, this will only proliferate that tenfold. And so the adoption process.
Senator Stewart.
Josh, if this bill reports out of here today and off the Senate floor, maybe with an amendment, will you work with these folks to try to see if there's a way your concerns could be alleviated? Or are you just absolutely opposed to the bill? I guess that's my question.
Mr. Chairman, Senator Stewart, we will work with anyone to consider anything that we think will promote families and give children a mother and a father. But we are concerned that this way, you're essentially guaranteeing that some people will be intentionally deprived of that and will go through the entirety of their lives never having had a father, never having had a mother. And that really should concern us all, I think. But we will certainly work with anyone we can, if possible. I see there's a minute, and I want to give my friend in the Catholic Conference an opportunity.
Yeah, thank you. And let me just say, we've interrupted you. I tried to stop the clock to do it, and like I mentioned to the patron, and it's like court. I would like to think that you'd appreciate us getting to the nub of it rather than letting you address things that may not be significant to members of the panel. So, go right ahead.
Mr. Chairman, members, my name is Tom Torsia. I'm with the Virginia Catholic Conference, and we oppose this bill. As Josh mentioned, we have at least 620,000 embryos already frozen and now stored in the United States. We share the concern that these embryos not be destroyed, but in our view, this bill only heightens that concern. And by extending surrogacy to allow its use by unmarried individuals without regard to genetics, this bill would create even more demand for the creation of new embryos. You've heard that discussed. Lastly, I would just add that if this bill is enacted, even in the substitute form, this would make Virginia's surrogacy law more expansive than that of Massachusetts and nearly as expansive as California in terms of allowing just about any non-genetic arrangement. In Massachusetts, the father of the intended couple must be biologically related to the child. So we believe that children in the embryonic stage of development are not property.
All right, Senator Norman.
Sure.
My question is very similar to what Senator Stewart asked a moment ago, and I'll try not to be more pointed than his gentlemanly behavior. I appreciate that your organization is not embracing this concept with great affection, but if this bill is reported out of here, do I have your assurance that you and your organization will work in good faith to try to find a common ground on it?
Well, Mr. Chairman and Senator Norman, I would have to defer to our board and our executive director for a decision on that. I don't have the authority to make that decision.
I would really
here and now.
encourage you to express your personal view, because, you know, if this report's out of here and y'all aren't willing, you ain't going to be at the table.
And I fully understand the tenor of what both.
And Mr. Chairman, I would
saying.
say I respect how your organization works, but sir, you're the guy in front of me right now.
Yes, sir.
And I can tell you, I'm just one little pissant in this process, but I'd be highly annoyed if those who are opposed to it did not work in good faith if it goes to conference to try to find an acceptable solution. And that's just me.
And if I may speak to the adoption point, sir, is the difference between adoption and this is that in adoption, we have developed case law under
Mr.
family
Chairman,
law.
I told you earlier today, I have done thousands of adoptions, and I've done thousands of adoptions through the Catholic Home Bureau in Hampton and Newport News. So I get that part really, really well.
If I may just finish, Mr. Norman.
Finish real quick.
Senator, just that family law is where adoption belongs. This proposal puts it in contract law. Family law protects the best interests of children, and we just want to ensure that the best interests of children are maintained. Thank you.
No, I appreciate it, and thank you for answering some tough and pointed questions. We appreciate it.
Thank you, Mr. Chairman.
Senator Stewart.
Thank you, Mr. Chairman. The issue for me here is just that these little lives should have a chance to live, and I don't know any other way to look at it. I have some concerns about the language, and I think this is a friendly amendment.
At least it's intended that way.
It's intended to be friendly, and if you don't think it's friendly, tell me. But the sentence that says, but the embryo was used is subject to the legal or contractual authority over the use of the embryo, I would move that we scratch authority over the use.
Where are you?
It would be at everywhere that's used.
For example,
which are
lines
multiple places.
line 107.
Yeah, we used 107 as an example. So I would strike authority over the use, and I would put the word custody in there, and then I would ask Kristen to define contractual custody in the bill when you are able to do that. So I guess that would be conceptual. But then it would read, embryo that was used is subject to the legal or contractual custody of the embryo by an intended parent. And I offer that because I look at this as a life, and I think we should address it as a life and not the way it was addressed, and I hope you look at that as a friendly amendment.
Senator Norman.
I second it.
All right, that motion has been made and seconded. You have any comment on it before we vote?
Mr. Chairman, just briefly, I can feel the train running. I do take it as a friendly amendment. I don't want that to be taken as my agreement yet that it's the perfect way to do it, but we are headed to conference.
We understand that.
Or at least potentially headed to conference.
I understand that.
So if we can together come up with something that works for everyone, I'm happy to have that conversation.
All right, the motion has been made and seconded. Kristen, you have it well enough in concept?
I think so, Mr. Chairman. Thank you.
All right. All in favor of that amendment signify by saying aye. Aye. All opposed? All right, that amendment is adopted. Anybody else have any questions of the patron?
Mr. Chairman, I'd move to report as amended.
Second.
I think Senator Peak had,
Oh, I'm sorry, I apologize. I'm happy to withdraw that motion. Okay, if he doesn't have a question?
Kristen, I think that there was one other amendment. No, we've adopted that. Did you have another amendment dealing with? Here. Kristen, is that drawn to the substitute?
This is the one I was looking for, Mr. Chairman. At line 290,
Senator Peak.
288, insert F. Any clause or provision contained in a surrogacy contract requiring abortion or selective reduction is void and unenforceable.
What? You make that motion?
I make that motion.
That amendment has been made and seconded.
What line again?
Can you report that, Kristen?
Mr. Chairman, 290 of the substitute, you would add a new subsection F.
Can you report it so that,
Yes, sir, Mr. Chairman. Subsection F, any clause or provision contained in a surrogacy contract requiring abortion or selective reduction is void and unenforceable.
Now, Mr. Chair, could the proponent of the amendment explain to me exactly what this is about? I mean,
Mr. Chairman.
Senator Peak?
Yes, Senator Deeds. This is a very difficult issue. I think a lot of people have a lot of sympathy for what they are going through. This is a very difficult issue for a lot of us who are pro-life conservatives, and this, for me to have any chance of voting for this bill, is going to have this kind of language.
Mr. Chair, I understand.
Senator Deeds.
I guess I understand that. I just wonder why in the world the issue of abortion would even come up when you're talking about a surrogacy pregnancy. I mean,
Mr. Chairman.
Well,
Mr.
maybe it
Chairman?
won't be a problem then. Senator Peak?
Senator Deeds, in a lot of these embryonic situations, they don't do it as much anymore. They used to put in more, and then a doctor would recommend selective reduction to the mother. And that is something that we have a concern about. And we don't want it to be included in the contract that they can do it. But if y'all have, anyway, thank you, Mr. Chair.
All right, that motion has been made and seconded to adopt that amendment. Any further discussion? All in favor of that amendment signify by saying aye. Aye. All opposed?
No.
All right, let's open the roll.
Aye 7, no 7.
All right, that amendment fails. The bill is before us.
Move report. Second.
It's been moved and seconded that the bill be reported.
Ayes 9, no 6.
Delegate, congratulations, and
Thank you, Mr. Chairman,
this
members of the
this is a hard bill that a lot of us really struggled over, and I just want to thank you for the thoughtful approach that you brought to the bill, and I appreciate your
I want to thank you,
efforts.
Mr. Chairman, and the members of the committee. I've spoken with a number of you, and I will be good to my word. I will speak, as we head towards conference, if we get that far. I'm happy to be as creative as we can be.
If we get to conference, we will certainly work with you.
Thank you, Mr. Chairman.
All right. Next, we have Delegate Poindexter.
Thank you, Mr. Chairman.
Delegate Poindexter, 2270.
Yes, sir. Very straightforward bill. We should be, for staff, we should be on the engrossed. There were some amendments. I don't believe they were made into a substitute.
Straight.
Right, okay. Mr. Chairman, members of the committee, this bill is very straightforward. It requires our local and regional jails to notify ICE forthwith as soon as the release of an alien is known from the court.
All right. Anybody have any questions of the patron?
Yeah, Mr. Chairman,
Sarah Edwards.
My experience, my understanding is the sheriffs do this. They do it and ICE just doesn't show up. They just don't have the resources for whatever reason to come pick them up.
That happens in many, many cases. It doesn't happen in some cases too, Senator. ICE has a risk assessment process that they go through when they receive notification. It's very sophisticated. They have their own database. They're involved in investigations with the CIA, DIA, and all kind of intelligence organizations that we don't really know much about what's going on. So they filter, if you would, the notifications, and using their risk assessment model will place a detainer or come pick the offending alien up.
Yeah, this is, I mean, not a new concept to us. Any further questions of the patron? I see the sheriffs are lined up behind you in support of this bill. Oh, they are. Okay.
Good afternoon, Mr. Chairman and members. We've worked with Delegate Poindexter, and I appreciate him working with us on it to remove the financial penalty and put the language in. We're doing a lot of this anyway, so we're in favor of it.
Okay. Anybody else want to speak in favor of the bill? Anybody in opposition to the bill? Step right up. Yes,
Good
sir.
afternoon, Mr. Chairman, members of the committee. Ryan Washington, Deputy Secretary of Public Safety and Homeland Security. Administration opposes the bill.
All right. Thank you very much. Next.
Hi, everyone. My name is Ashna Khanna. I'm the Legislative Director for the ACLU. I'll keep it short. Frankly, this bill we seem is unnecessary. The Virginia law already requires that ICE be informed when a person is arrested, taken into custody, when the person is convicted. And so Virginia should be moving away from volunteering local resources to federal government for immigration enforcement. At large, it makes our communities less safe, less likely to go to law enforcement as well. Thank you.
Right. Thank you.
Good afternoon, Mr. Chairman, members of the committee. Lana Martinez with CASA, Virginia. This bill undermines any justice that's in our criminal justice system by stripping the rights to due process. It impacts people who have not been convicted of any crime. They may have just be waiting for release in order to await trial. It also impacts people of every immigration status, as well as people of no status, and of course their citizens, spouses, children, coworkers, neighbors, and friends. I brought a story, but I will save that story, save you some time. I just want to end by saying that this is a bill that creates problems in the Commonwealth. It sends a message, and more importantly, it has real dire and detrimental effects on families who are desperate to know why the state has disappeared their loved ones when they go to pick them up upon release, and ICE has already taken custody, and the family has no knowledge of this.
Okay.
We're opposed.
Thank you.
Mr. Chairman, members of the committee, Ben Hoyne of the Virginia Interfaith Center, representing tens of thousands of people of faith from across the Commonwealth. We are opposed to this bill. Virginia has a long history of welcoming immigrants. Welcome my family, I imagine welcome many of yours. This legislation is discriminatory and it divides us as a Commonwealth. Immigrants are an important part of our community and our economy. Virginia should be championing diversity as it makes us better people. This bill takes us backwards, and we oppose it. Thank you.
Okay, thank you.
Mr. Chairman, members of the committee, good afternoon. My name is Fareed Zaman. I'm with the Virginia Coalition for Immigrant Rights. HB 2270 proposes to force local and regional jails to notify ICE anytime any non-citizen immigrant, whether or not they're unauthorized or ICE has any interest in the person, is due to be released from the facility. In addition to its overreach in dictating to local jails what they must do, should this bill become law, it would send a harmful message to immigrant communities about their welcome in Virginia. This is what happened in Arizona back in 2010 when the state passed SB 1070. It gave broad authority to local law enforcement to act as immigrant agents and target potential undocumented immigrants. According to a published research paper from A&M University, despite most provisions of SB 1070 being thrown out by the courts, the message it sent caused 10% of the non-citizen Hispanic residents of Arizona to flee the hostile environment. This led to a sharp decline in tax revenue and left key industries from construction to food service and hospitality struggling. The same would happen here.
Thank you very much. All right, the bill is before us. Anybody have any questions of the patron? Is there a motion on the bill? All right, it's been moved and seconded. The bill be reported. Roll is open.
Ayes 906.
All right, your bill reports. Couple real quick. Delegate Hugo, step right up. Delegate Hugo has the felony murder bill 2509. No, I'm sorry. That is.
I'm glad to take that, but.
Do we not have that on the docket?
No, sir. This was an easy one. It's Virginia self-storage.
We did it on Monday. Never mind. I'm sorry.
House Bill 2509.
All right. Delegate Hugo 2509 just deals with how you conduct an auction.
Allows you to have an online auction and requires.
You aware of
that they
any
have
opposition to the bill? Anybody in the audience here speak in opposition to it? Bill is before us. It's been moved and seconded. The bill be reported.
Thank you, Mr. Chairman.
Thank you very much. Next, we have a couple of things we're doing real quick, and I apologize to the patrons who are here. Delegate, you okay with that, Collins?
No, I want to keep, I'd rather just pass this bill by or pass it as it is, because he's not here and I haven't had a chance to talk to him.
Let's put it in conference.
He texted me and asked me not to.
All right, Delegate, I'm sorry, which one? Delegate Bell? 2773. This is the Criminal Injury Compensation Fund bill. It increases the amount of funds available to be paid to crime victims. It doesn't involve any general funds. My understanding is that the fund believes that they can handle that internally. Is that correct?
That's correct, Mr. Chairman.
All right. This needs to go to finance. All right. Is there a motion? Anybody here speak in opposition to the bill? All right. There's a motion to report and re-refer the bill to finance. All right. And Delegate, all right, that is reported and re-referred. All right. And Delegate Bell also had his airbag bill that we heard on Monday that there's an amendment for to address the concerns that Senator Peterson raised concerning the impact of a criminal offense upon the civil liability, intervening criminal acts of a third party. Senator Stewart moves. Senator Howell seconds the adoption of the substitute. All in favor signify by saying aye. All opposed? My understanding is that this is agreed by the patron, by the industry, by the trial lawyers, by everybody who's expressed an interest in this. Anybody here speak in opposition to this substitute? Hearing none, is there a motion to report this substitute? It's been moved and seconded. The roll is open. All right. Delegate Austin.
Mr. Chairman, ladies and gentlemen of the committee, I have House Bill 2622. It's
next of kin bill relating to foster care.
All right, 2622. Delegate Austin, this replaces, it changes the term, a term to persons with a legitimate interest, but it also requires production of personal information. Is that right?
Just to notify the court of the next of kin.
Okay. I understand that there are some people here to speak in opposition to the bill. You want to briefly tell us what the bill does?
Yes, sir. I can briefly tell you what the bill would do. The court shall order the parents, guardians of such child to provide the names and contact information for all relatives or other interested individuals, including grandparents and extended family members, to the local Department of Social Services. This was a JLARC recommendation.
Okay.
Thank you.
So this is part of the foster child?
Yes, sir.
Foster children's report? Okay.
Yes, sir, that's correct.
All right. Those who wish to speak in opposition, step right up.
Thank you, Mr. Chairman. Valerie LaRue from the Virginia Poverty Law Center. And my concerns about this bill are threefold. One is that a parent may have a good reason for not turning over a relative's name. For instance, if a relative might be known to be an abuser. The other thing is that the parent will be subject to legal jeopardy because she can be held in contempt for not turning over names. She may not know all the names and contact information of relatives. And third, it removes the discretion of the court. So the bill says that the court shall require that parents do this. It may not be necessary in many situations. And so by saying that the court shall order the parent to do this, you are taking away the court's discretion. So for those three reasons, I ask that this committee not report this bill. Thank you.
All right. Next.
Mr. Chairman, members of the committee, I'm Allison Gilbreth with Voices for Virginia's Children. You may have heard me recommend bills for kinship care in the past, and we are very supportive of two other bills that have made it out of committee. We oppose this bill for the exact same reasons as my colleague from Virginia Poverty Law Center said before, and we also host the Virginia Campaign for a Trauma-Informed Virginia, and we don't think that this bill is trauma-informed, and for those reasons, we ask you not to report this bill.
All right. Thank you.
Mr. Chairman, Doug Smith with Families Forward Virginia, formerly CHIP, Impact Virginia, and Prevent Child Abuse Virginia. Just for brevity's sake, the real key seems to be on line 17 of the bill. It's a shall. If it were moved over to may, it seems like it would give more discretion to the court, and that would solve many of the concerns.
All right. Thank you.
I move that amendment.
Delegate, we may take action on an amendment and continue the discussion. Senator Edwards moves. Is there a second? There's motion properly seconded to adopt the amendment. Any discussion? All in favor signify by saying aye. Aye. All opposed? All right. Note your noes. Okay. There are 2 noes. All right. The bill is amended as before us. Is there a motion? It's been moved and seconded to report the bill. All right, that bill as amended is reported.
That's 14 as 1.
Didn't like your amendment, John, huh? Yeah. All right, next we've got Delegate Collins. It's not here. Delegate Herring. Delegate Herring, we have House Bill 2417.
That is right. Mr. Chair, members of the committee, 2417 has to deal with emergency protective orders. Right now, if you look at the emergency protective order form, there are 2 conditions that a magistrate can check regarding that protective order. One would be the respondent cannot commit acts of violence, force or threat. Then there's another condition that the respondents stay away from the victim. So this bill will require that both boxes be checked. And the reason is that they're still allowing contact in an emergency situation. This bill is a result of a work group that was conducted by the Alexandria Police Department and the Alexandria Domestic Violence staff. The respondent will still have time to ask for a change in the protective order. But when we're talking about an emergency situation, it just makes sense that the person also be required to stay away for that 72-hour period.
Steve, Senator Stewart whispered his question in my ear, which is the same question that we discussed as to whether this is necessary. I think he's looking.
The question I believe you asked, Mr. Chairman, is whether this is necessary.
That is it.
The court can and is directed to consider all of these things, including all of these items, in a protective order. The court is not mandated to do that, but quite frankly, I've never seen a protective order that didn't prohibit exactly what this bill prohibits. I'm not aware that it's a problem, in other words.
And I guess following up on maybe earlier debate today, why would we take the discretion away from the court?
Mr. Chairman, it's never, well, Mr. Chairman, the committee historically has tried not to take discretion away from judges.
You want to close?
So I think I need to respond, and Mr. Chair, and I also like a witness to testify about why. But I would say this, is that obviously there's a problem when we have Alexandria Police saying that there's a problem. I'm just going to say that, because what we're doing is it's not clear. Someone says, okay, I'm not allowed to hurt the person, but I'm allowed to have contact. And we know in these situations, things can escalate.
Well, if Alexandria wants to step up and be heard, we'd be more than happy to hear from her.
Good afternoon. Sarah Taylor, City of Alexandria. And yes, it did come out of a work group with our cops, our courts, our magistrates, and their view of this was to make the emergency protective order as tight as possible, as protective as possible, as clear as possible, both for the petitioner and the respondent, and then give a path for how to walk it back if that is necessary.
But is there a problem that actually exists? Can you identify that?
In our community, it has been identified that there is, and there were other...
What is it?
That magistrates are choosing one or the other of these.
What problem has that caused?
It's caused where they check the one about not harassing or threatening person, but that they still are in contact with the person. They would text, they would call, they would be in physical contact with them, come to their properties. And by making them both required at the outset, it would kind of lock it down and make it as tight as possible. I'm sorry.
Mr. Chairman, that is a contact issue, but the language that we're talking about doesn't affect whether they have contact or not.
Mr. Chair and Senator McDougall, my understanding is that on the protective orders, there are two boxes, one about committing acts of family abuse or criminal offenses, and the other box has to do with having no contact of any kind with the petitioner. And that by keeping those both required from the outset, it makes it as clear as possible to both the petitioner and the respondent what the requirements of the protective order are.
Right.
And then giving a path for them to walk it back, which gives self-determination to the petitioner for how they want this to go in the future.
Senator McDougall.
Mr. Chairman, if you have no contact, then you can't have anything that would result in a negative physical act, because you can't have any contact. So if you're going to allow contact, which sometimes in these protective orders, it's wanted to do. There's children, not just the party involved in the protective order, and you want the person to be able to have contact, but you don't want them to do anything damaging to that person, so you would check that box. So I'm not understanding, if you say no contact, that means you can't touch them.
Right.
So
and so there is a box. I wish I should have brought copies. The first box says the respondent shall not commit acts of violence, et cetera. Then there's the second box. In order to protect the safety of the alleged victim, the respondent shall have no contact, and then it's filled in, right? You can say the petitioner, but maybe they can have contact with the children. So that flexibility is there because we can specify, but the problem is sort of it's counterintuitive. You're saying don't commit acts of violence, but then you're allowing somebody to come into the space of the petitioner.
Well, Mr. Chairman.
Senator McDougall.
That's the part that I think there has to be some flexibility for. I mean, that's two separate potential issues, and it depends on what the allegation is. If it's a domestic assault that they're getting emergency protective order, it's going to be no contact. If it's something else, there might still have to be contact with a family member. And these are not just for the petitioner, they're also for all the family members. So
Senator-
you would,
Mr. Chairman.
without that two separate opportunity, you can't do
Senator
that.
Stewart.
Mr. Chairman, Senator McDougal's exactly right. There are situations when there has to be limited contact. The statute currently gives the judge the flexibility to manage that as it needs to be managed. And I'd move the bill be passed by.
Mr. Chairman,
Senator
I might add to, if Senator Stewart would consider this, that maybe we could ask the Forms Committee, the Committee of District Court, to see if they need to, the verbiage on that line needs to be clearer if certain individuals are not able to grasp that no contact also means no acts of violence. It
Just so
seems-
happens that I think the delegate is on the Committee on District Courts.
I certainly am.
And we might be able to arrange to pass the bill by with a letter. How about
sounds
that?
good. Well, yeah. Yes, I'll take it. I
Okay.
have to take it, so
All right.
I know where it's going. So.
Motion is to pass the bill by indefinitely with a letter.
All right.
It's not what she wants, but,
No, it's not what I want. Sorry. Thank you.
all right,
Appreciate it.
thank you.
All right.
And next we have Delegate Campbell, Delegate Watts.
You have Norman's back.
Thank you.
Thank you, Mr. Chairman. I have two bills before you.
All right, we've got 2080.
And 2080 is a continuance of the efforts that began several years ago to really take care of the
So
problems.
you aware of any opposition to this bill?
None at all,
Department of
and
Forensic
agency is very
Services supports
happy.
this.
The amendment was good and so on.
Well, wait a second. Anybody here in opposition to the bill? And this is just a cleanup bill for tracking perk kits. All right, motion properly seconded to report the bill. And 2089. This is similar to Senator Mason's 1418, which reported from this committee and from Finance and passed the Senate unanimously. You like yours better than Senator Mason's?
It is my understanding from Senator Mason's, and I was not aware that he had one, that actually the substitute language for his bill is my language. That was my understanding, what I was told by Senator Mason today.
Charles?
He may have requested that in the House. We passed it out as introduced. So he may be agreeable to your language, but.
Okay.
How about if we conform it and we'll work it?
And we'll
It
work
sounds
it out,
like
yeah.
we're so close, we'll work it out.
Mhm.
Don't want to make a mistake.
Mhm.
It needs to go to Finance, is that right?
It
does
has a
not.
delayed enactment clause, it does not.
All right. Senator, if it's conformed to Mason's?
Mason's will.
All right. Senator Deeds moves, Senator Stewart seconds that we conform to Senator Mason's and report. Roll is open. All right, Delegate Hope,
That's
Delegate
15-0.
Lopez.
Thank you.
Good afternoon, Mr. Chairman, members of the committee.
Afternoon, Delegate Lopez, 2396.
Yes,
Is that right?
2396. Basically, in Virginia, a company has to tell a customer when there's been a data breach in the internet and their personal information has been
Delegate,
stolen.
you aware of any opposition to this bill?
No, sir.
All right, this protects military IDs just like your social security number,
Yes,
is that
just
right?
like Social Security and your debit card, your financial information.
All right,
So
anybody
it's military
here-
IDs and passport information.
Anybody here in opposition? Bankers hate this bill? All right, it's been moved and seconded, the bill be reported.
Thank you, Mr. Chairman.
All right, is that all you have?
That's it. Thank you, sir.
All right, Delegate.
That's 15-0.
Davis. All right, we're gonna have to suspend in a minute. Okay, never mind. All right, Delegate Davis.
Yes, sir. Mr. Chairman, House Bill 2127, I can tell you the same thing. The Family Law Coalition supports it. Family Foundation supports it. Everyone's happy. I believe it came out unanimous out of courts. And
everybody where is happy?
Here?
Now, we're pretty unhappy today.
I can present if you like me, Mr. Chairman.
All right.
I just want to know, Mr. Chair.
Senator
I
Deeds.
just want to know, in line 11, we're talking about best interest of the child. Why do we need to require that the court, when appropriate, assure frequent and continuing contact with parents? I mean,
Well,
it's in the next statute, when considering custody, they do that, but why do we need to do that when we're considering the best interest of the child?
sure. So, Mr. Chairman, I would say that that is in section 124.2, related only with determining custody. Section 124.3 not only relates to custody, but also visitation arrangements. And so that's why it's in this section, and it was a piece put together, like I mentioned, by the Family Law Coalition and the Family Foundation, Mr. Chairman. So it brings it to both sides of the equation. I can explain.
So the Family Law Coalition supports this in
Yes.
addition to the Family Foundation?
They were the ones that actually suggested the amendment in committee.
Yeah.
Good afternoon again. Julie Stillo with the Virginia Family Law Coalition. I apologize for speaking in opposition of a bill that you are under the impression we support. My understanding from the coalition, speaking as their representative, is that in the House version of it, it was phrased that under the 20-124.3 that the court shall consider frequent contact. The way it currently reads is that that the court shall assure, and by putting the shall assure in 20-124.3, it now suggests that that is a definition of best interest. The coalition has heard from members of the bench that their concern is that this creates now a presumption of some kind of custody schedule leaning toward a 50-50, and it takes away their judicial discretion, which I know the committee has spoken a lot about today.
All right, I tell you what.
Address it further, but that's
Stop 1 second. We are under some rather intense time pressure. And this is going to take maybe a little bit longer than we have right now. So we're going to suspend on this bill unless there's an objection. Okay?
Yes, sir.
All right. We're going to run through a handful of bills that maybe we can get through pretty quickly. First is House Bill 2296, Delegate Leftwich's Persons with Disabilities Bill, which we've heard before. My understanding is that we have a substitute that, to the best of my knowledge, there is peace on dealing with these lawsuits under the Disabilities Act for accessible websites. Rather than creating a civil procedure, this would place it in the Virginia Disabilities Act. So this had not been shared? What?
Yes, Mr. Chairman.
Do you not, has the opposition not seen this?
No.
Well, then we're not going to do it right now. I don't know. All right, next we've got 1814, nope. Campbell, not here? You're here for Campbell?
Yes, sir.
1947, is that right?
2262 for Campbell.
2262.
Yes, sir.
Delegate Dix, Mr.
Chairman.
Dix.
That's bad. Has been, Mr. Chairman.
I'm old enough to remember.
Me too. So what this bill does.
Not calling you old. Yeah, actually I am.
Neither one of us are old, Mr. Chairman. It's all how you feel. So all this bill does is to clarify that it's a property manager pursuant to a written property management agreement. There's no opposition to the bill that I'm aware of.
All right. Anybody here in opposition to the bill? Anybody have any questions of Patron? All right, the bill is before us. It's It's been moved and seconded the bill be reported. You're doing pretty well for him. You don't want to take his other ones? What else do we have that's, right, we have 2666 from Delegate Bell. This is a Department of Criminal Justice Services training standard bill. As has been our practice during this session, we're going to send this to the training committee unless anybody has an alternate view. That's what we did with our members' bills. Is there a motion to that effect? It's been moved and seconded to pass the bill by indefinitely with a letter. He is?
I-1302.
Huh? Hope? I'd take last year's language. We worked that through thoroughly, both houses. Huh? And his bill's gonna. All right, Delegate Hope. 18.
I'm just pulling up my bill, 1815.
1815, 1814. Yeah, all right. How about this deals with deferral of jury service. Our trial lawyer on the team, Mr. Benjamin, you have thoughts about the necessity of this bill?
Can I explain it, or where is he?
Oh,
there he is. I'm sorry, you're right there.
We're on a roll, so
All right.
we don't. We'll give you an opportunity to address it, but
Doesn't sound good.
listen to the concerns, and then you can address those.
The concerns that we identified, Mr. Chairman, centered around the necessity of the bill, because if a person can already get an exemption, we were uncertain why they would want a deferral. And we asked, would it make more sense for a person to request an exemption when they need it?
Yeah. No, and that's right. I mean, this was brought to me by a constituent, has 3 kids. They were summoned for jury duty in the summer, but they needed to be around to take their kids to and from camp. They didn't want to be exempted. They wanted a deferral because it would be better for them to be in a jury pool when school is in session. And so they didn't want to take themselves out of that, but because they want to serve on the jury. But they just, during that time, was inconvenient for them, so they wanted a deferral instead of the exemption. But there's not an exemption for that case. And that's what we're trying to do.
Mr. Chair. All right. Anybody paying attention? Okay.
Yes.
We give, and I was not, I apologize, but I just don't see the necessity of this bill.
Senator Peterson, hold on, can I ask Senator Benjamin a question?
You can ask counsel a question there, Senator Peterson.
All right. Right now, people get called to jury service all the time. I don't think they check the number of children. So if someone's asked for voir dire, they say, can you be here for 3-4 days of trial? They say, no, I got to take care of my kids. I guess my question is for Mr. Benjamin, is this an automatic? I mean, is this where you get yourself taken off the rolls altogether, or is this more where you're sitting in the jury box and you get asked whether or not you can sit through a 3 or 4 day trial, and this is one of the reasons that you give that you cannot? Because if it's the latter, then I don't see why we need the bill. If it's the former, I think perhaps we do.
Mr. Chairman, with apologies, I'm not sure I followed the question.
Well, sure. I mean, if you're called for jury duty, they don't typically do an investigation as to how many kids you have. They just call you for jury duty. You then show up at the courthouse. Yes.
Well, it's even before that. You get summoned, but there's a list of different exceptions, or for, not an exception, but an exception. But there's no exception for this situation where they don't want to be taken out. They want to do it. This will increase our jury pool. But the only option that my constituent had was from an exception. She wants a deferral because in a couple of months, her schedule's going to be clear and she wants to serve.
So let me just follow up. So in other words, on the summons, you
Right,
can check a
exactly.
box saying, I don't need to appear because I'm caring for a child under the age of 16.
But,
Correct.
I mean, how does the clerk keep track of this?
Yeah, that's the question.
You know, this is like volunteer juror. I mean, I really want to serve on the jury, and that's wonderful. I applaud the civic engagement, the desire to perform their duty as citizens, but, you know, they'll come back up. Their name will come back up. But to ask the clerk to, you know, keep a list and keep track of when my children are going to be in school and when I might be available, I wish Mr. Dix was here still, but I don't see how they can do that. I mean, I don't see how it's possible.
I mean, I haven't heard anything from the clerks. In fact, my clerk said that they supported it from Arlington.
Mr. Chairman, as
Senator
a
Howe.
stay-at-home mom, I kind of think this is important because I can remember basically that happening to me. I wanted to be on a jury. I thought it was my duty to be on a jury, but I was taking care of my kids during the summer. The rest of the year, there were lots of times I could have done it. And I think that, frankly, the jury pool would have benefited from my being in it.
Well, of
So-
course.
Yeah. So I mean, I do think it's a problem, and I don't think it's overwhelming for the clerks to deal with.
Okay, somebody had a question over here?
You would come over here.
Mr. Chairman,
This is Senator Sturdivant.
I think it's also permissive language. Not every clerk's office would have to do this, as I understand it.
Chip, you love this bill?
Mr. Chairman, our clerk, Paul Ferguson in Arlington, worked with Delegate Hope on this bill.
Does the association have a position on it?
The association is okay with the bill.
Does it support it?
I believe we have a monitor on the bill, Mr. Chairman, as an
So
official.
it doesn't support it, doesn't oppose it?
Right. We looked at it, and it was worked out by one of our clerks.
Is it something you could handle? I mean, I guess maybe that was the question you asked, Mr. Chairman, whether if someone deferred jury duty for a couple of months, is that going to be a burden for you?
Y'all going to keep a list?
Mr. Chairman, I don't know that we're gonna keep a list of that. I'm not sure exactly how we.
Mr. Chairman?
Senator McDougal.
Maybe we can parse through the difference. I guess some of us may be having a little trouble with the new language in line 21, in that 2021, in that section. But if you were just adding into the deferral at the request, that might alleviate some of the concerns.
Deferral.
You can do
Yeah.
this.
Is that, Mr. Chairman,
At the request.
Steve, does that make sense to you? So you're still saying that you can exempt from jury service at your request. We leave that the way it is today, and then we just go with that 8.01, 341.2, and just saying at the request of the person selected for service. So we just let them add that. That might
I think that would
alleviate-
still work, yeah.
That might alleviate some of the concerns that we
All right,
have
you
about maintaining a list.
Making that
I am.
move in that amendment?
I am.
All right, it's been moved and seconded. All in favor signify by saying aye. All opposed? All right. Any other questions? Bill's before us. Yeah.
Ayes 12, noes 3.
Thank you, Mr. Chairman. I appreciate it. I appreciate everybody.
All right. Delegate Collins. I think we have an agreement that you're going to we're going to make an amendment to your hands-free bill. Yours and Senator Stewart's will go into conference, and we will work in good faith together to try and and make sure that we have a workable bill.
Yes, Mr. Chairman, my understanding.
Senator
Go ahead.
Mr. Chairman, I think Delegate Collins is agreeable to amending, and I don't know what the line is, but where it says hold, just amend it to say in your hand, hold in your hand. In your hand. And
In
that
his hand,
clarifies it. And then I understand that the chairman of this committee has some difficulties with the language. So Delegate Collins and I are happy to work with the chairman of this committee and others to make sure that we've got the best language we can have so we
Okay.
have a good hands-free bill.
Yeah, as long as we agree that this is going to go into conference, Senator Stewart moves the amendment.
And then it's
Senator
gonna
Chapin
come out.
Seconds.
I think the agreement was it's gonna
good
go
faith
in
that
and
we will
come
work
out.
Together on that. All right, all in favor of the amendment signify by saying aye. Aye. All opposed. That amendment is adopted. The bill is before us.
Second.
Ayes 15, no zero.
Okay.
You got a better vote than I do.
Thank you. Thank you, Mr. Chairman.
Yeah, that's what it is.
Next, we have Delegate Aird. And we can't do that. Delegate Campbell. We can't do his. We've done 1947. Charles, can you do that?
Mr. Chairman, House Bill 1947 basically provides that any person who makes or communicates a threat to destroy or bomb a private or public elementary school or communicates the same information knowing to be false shall be guilty of a shall be guilty of a misdemeanor, which shall include 5 days of mandatory minimum confinement.
Mr. Chair, 5 days. Mr. Chair.
All right, Senator Sturman.
I understand the desire to have this penalty
You
for
turn your
threats of
microphone on.
bombing, burning.
Microphone, please.
Can you hear me? So I understand the need to have this kind of penalty for threats of bombing and burning, but it also includes communicating to another about damage to a private or public elementary or secondary school. And so my concern there would be a situation of like a senior prank of some sort that we obviously don't condone, but that could result in a mandatory jail sentence.
So if you said there's, Mr. Chairman?
Senator
So if you said
McDougal.
there's a tornado that's about to hit the building?
What?
If you said there's a tornado that's about to hit the building, that's
Yeah.
5 days mandatory minimum?
I just, Mr. Chairman, having grown up in Spotsylvania County, I recall the senior prank was like letting a pig or a cow into the high school, which would result in a mandatory minimum jail sentence. That,
I'm not sure we
no
ought to
would be
deal with this
justified.
without Delegate Campbell being here. You concur? Well, we can, how about, we ready on Delegate Leftwich's bill? Everybody had a fair opportunity to review it or not?
Mr. Chairman, I would like to say that when I met with you in the hallway this morning, I did tell you that the disability community, I thought, would continue to oppose the bill, that this was a new version. And so I don't want to leave anybody with the impression that that was not made to you and several other members of the committee.
No, and I understood that there were going to be concerns. I just thought that they would have seen it, so that was all.
Delegate Leftwich is chairing a subcommittee. I understand he's en route, but Matt Bruning on the bankers and
My understanding is that this bill simply addresses the same issue, but through the Disabilities Act, and creates and addresses it largely in the same way. But rather than creating a civil procedure, it simply adds to the guardrails that are already built in the Disabilities Act. Is that right?
Yes, it's within the framework of current law, which has a one-year statute of limitations and says, even though it's a one-year statute of limitations, you must file within 180 days your bill of complaint unless you provide a written statement to the presumed defendant about the nature of the circumstances.
And it still requires the defendant to correct the problem in order to avoid potential damages.
It would give the defendant an opportunity to comply with the law by complying with that website accessibility guideline. Yes, sir.
All right, Kristen?
Mr. Chairman, the language of the substitute doesn't say anything about specifically giving the defendant an opportunity to cure so that the case may be dismissed. In addition, it still has the case cannot be commenced sooner than 120 days after the complaint is filed, which the committee had expressed some concerns about last time that we were imposing this new rule for this very small class of cases. The other thing that the substitute does on the back page in the subsection C is it has those standards, guidelines in it that the committee was also unsure whether or not it wanted to include in the code.
Ma'am, that's a correct recitation. I would like to point out that the substitute before you is within the current statute of the rights of persons under disabilities, where they're already required to file a statement to the
in order to
defendant.
make a claim, you have to make your claim within the parameters of Title 51.5.
That's
right? And we're not messing with the pleadings provisions or the civil cause of action provisions under Title 8.01.
That's
right? Okay. All right. Anybody else, anybody wish to speak in favor? Anybody else? Matt?
Mr. Chairman, members of the committee, Matt Brittany with Virginia Bankers Association. Similarly with Senator Barker's bill, that we appreciate working with the credit unions on advancing this legislation. Hopefully it's a more receptive version that you have before you. But this is a problem for our financial institutions in Virginia that are seeing these suits and these demand letters. We appreciate your support on the bill.
All right. Let's hear from those in opposition to the bill.
This is Colleen Miller from the Disability Law Center. Mr. Chairman, this is the same bill that the committee saw the last time, a little bit worse and just located in a different section of code. So what the credit unions have complained about are actions under the Americans with Disabilities Act. This does not solve their problem. This is an attempt to limit the rights of people with disabilities under the Americans with Disabilities Act by going through the Virginians with Disabilities Act. This will not actually help the credit unions. So, for example, if I'm representing somebody who alleges the website is inaccessible, I'm going to file under federal law. This will not apply to that, but the credit unions might assume that it will apply to them and they won't respond to the complaint. Or they'll allege that something is, that they're entitled to another 120 days. And then I'll get a default judgment out of it because they didn't respond in time. It complicates federal law in a way that doesn't help them.
Well, I mean, and all the time we have parallel remedies under state law and federal law. And if a cause of action is filed under both, or the plaintiff elects to file under the Virginia Disabilities Act, doesn't this address that?
It does not address the remedies under the Americans with Disabilities Act.
No, I understand,
It cannot
but under the
address
Virginia Disabilities Act, it does.
And none of these cases that the credit unions are concerned about have been brought under state law. None of them. Anywhere in the country are they being brought under state law.
And I do understand that, but why would you oppose it then?
Because it is going to give the credit unions the impression that they have this extra time to come into compliance with the law. And my colleagues who can't access their websites now.
But nobody's bringing those suits under the,
But
you said that nobody's bringing the suits under the state act.
That's right. But the credit unions are going to be under the impression that because of this, because of the problem they've identified, that they've got all this extra time, they don't have to come into compliance until they've been given this 180-day notice, and their websites are not going to be accessible. In much the same way that this substitute bill here is not accessible to my friends from the National Federation for the
Mr.
Blind.
Chairman, can I ask, if you look at lines 29 through 32, can you speak to that, because you were speaking
That's
to
right.
the other provision.
yes.
Can you speak to that provision?
And Senator McDougal, Mr. Chairman, Senator McDougal, that part of the statute is good.
That part is
The
good.
proposal. We actually suggested to the credit unions to go forward with that, because part of the complaint that they have had is when they're threatened with these suits, they don't have any proof of compliance, and we thought, let's go forward with that.
Mr. Chairman, how about?
Senator McDougal.
'Cause I know there was some consternation when the other bill had, what if we just move forward with that, the changes on line 29 through 32 while they continue to talk about this bill? Keeps it moving through the process.
You want to make a motion?
So make a motion to amend the bill to only include the new language in line 29 through 32.
So to strike the language at 20, new language at 22 through 25?
Yes.
Kristen?
Mr. Chairman?
Yeah.
If we were just to go forward with those lines, it would be preferable to do it as a new code section, because otherwise there's no reference anywhere else in this remedies section to website accessibility.
Can we make it 46.1?
Yeah, that's right.
That's your motion?
That's, yes.
All right. Is there a second to that motion? Whit, this keeps it moving.
Thank you.
Mr. Chairman, speaking to the motion, the only concern about the motion is that you are eliminating the 120 days to cure. That would be our concern about that.
All right.
To give these financial institutions.
But
an
at least
opportunity.
it's on life support.
Mr. Chairman, if I remember correctly, the Senator Barker's bill did not meet with affinity and leave this committee, so this amendment will likely leave this committee.
Yes,
And allow it to continue through the process for another week.
I understand.
All right,
Thank you.
there's a motion properly seconded. All in favor of the motion to amend signify by saying aye. Aye. All opposed? The amendment is adopted. The bill is before us.
Mr. President, I have a question for my own edification. What are the remedies in state court? I know with remedies in federal court, I've done it, but are there any remedies under state law?
Mr. Chairman, Senator Edwards, very few actions are brought under state law. My office typically only brings forward-looking relief, prospective relief, so I'm not familiar with all of the,
So-
I believe
And-
damages are available.
And
but
that's
I'm-
not part of the bill.
No, I understand, but it's my understanding there are no remedies for private cause of action under state law.
I think that might be correct.
Mr.
Okay.
Chairman, the remedies are listed on lines 13 through 15 of the substitute.
All right. All right, the motion is to adopt the bill as amended. And I'm informed that Bill, as amended, reports. Right, I'm informed that, and I know that Delegate Aird may have just gotten here, but I'm informed we've got to go. I know, I'm sorry. Delegate Ward is here, I'm sorry. We can't.
I've never brought a suit in. I don't think anybody has.
We will suspend, and if we're able, we'll come back. We've called those bills, so the committee will rise. We are at ease.